In this lecture, we're going to talk about ethical issues and the rights of clients. After engaging in this presentation, you should be able to define the term client, describe the impact of Wyatt versus Stickney on ABA and the treatment of clients in general, recognize and explain the rights of clients, define and discuss informed consent, distinguish between surrogate and guardian roles and the relevant considerations for behavior analysts, define and discuss confidentiality and ways to maintain records. Describe responsibilities of behavior analysts in relation to third-party involvement in services. So, what do we know about the history of clients and behavior analysis? Well, in early times, in the early history, the focus was more on the employer or the institution. So behavior analysts worked for mental health hospitals or they worked for schools, and the focus was on meeting the employer needs. That moved to a focus on parent rights. So treating the parent as the main client. They were the ones who made the treatment decisions. They were the ones who decided the goals, where the treatment should be carried out. And now we've moved into the rights of clients to make their own decisions for their treatment. So that's how client has evolved in the history of behavior analysts, from employer institution to parent to client driven. Wyatt versus Stickney is a court case from the 1970s. You're going to watch a video right now on Wyatt v. Stickney. The outcome of this case was that patients have a right to receive individualized treatment or be discharged to the community. This is the first time the term right to treatment was put into the legal arena. Several standards emerged from the Wyatt case, including that services had to be delivered in humane and least restrictive environments. You had to have sufficient qualified staff, and individualized treatment plans had to be included. The new goal was that you had to do your best work and you were responsible to make sure the person receiving the treatment was not harmed. There were several early challenges in relation to clients for ABA. Some of the initial concerns were that often it was the desire of staff to manipulate clients' behavior in order to make their lives easier. So over time, a balance emerged between we have to do what's best for the client, but then also sometimes issues with the people who support the client also emerge. So you will have this ongoing ethical dilemma related to how do I balance the needs of the first party, such as the client, which remember can include the parents, the second party, which could be people like behavior analysts and teachers, and the third party like school districts or clinics or institutions. By the 1980s, behavior analysts were more widely accepted in the treatment of disabilities and often were part of treatment teams designed to lay out treatment plans for clients. So this forced behavior analysts to put other protections into place. In the 1980s, the Association for Behavior Analysis commissioned a blue ribbon panel to lay out clients' rights in applied behavior analysis treatment. This report is outlined in the Van Houten article from 1988. So now let's talk about the professional and ethical compliance codes related to clients. Code 2.0, and remember these are the codes, the current codes, so those available on the BACB website and in Module 1. It is not the codes referenced in the book because remember the book is outdated. The behavior analyst has a responsibility to operate in the best interest of the client. Your dilemma every day that you are practicing is going to be, is this in the best interest of my client? As part of that, Code 2.0 relates to accepting clients. You should only accept clients that are within your realm of practice. So if you typically work with preschoolers, it would not be appropriate for you then to take on clients who are young adults, unless you're going to be supervised or consult with others in order to gain experience and knowledge in how to treat young adults. Remember again that client can refer to the actual person you're treating, their parent or guardian, an institutional representative, a public or private agency, and a firm or corporation. Clients can also be direct, which would be a direct person you're working with, or more indirect. So for example, a wider implication of clients might be all of these students in a district who have emotional disturbances. If you were consulting with the school district on cases of children with emotional disturbances. So you might not actually go out and directly work with those clients, but the people that you work with will work with those clients. Before accepting clients, you want to consider, has the problem emerged suddenly? Could this be a medical cause? Does a medical evaluation need to be done? And is the problem with a client or with someone else? You have a responsibility to all parties affected by behavior analytics services. So if multiple parties are involved, like different agencies, different professionals, you need to establish a hierarchy of parties and how communication will be done. You always need to remember that you're going to advocate for the client and their best interest. A key consideration of this is protecting client dignity. You have to honor their choices. You need to find a way where the client can help select the outcomes and what behaviors they want to target. This may not always be the exact ones that parents or teachers want to target, but you need to have balance and honor their choices. Do you provide adequate space for privacy? And do you look beyond the disability and treat the person with respect? This might look like if you have a client who's nonverbal, still speaking to them as you would anyone else, even if they cannot verbalize back to you. If you're going to consult, and this could be consultation as in consulting with the school district or medical professionals, or it could be pulling in other professionals or other behavior analysts for consultation. Whatever you do, it should only be done in the best interest of the client and only after they consent. Many times in consultation, you'll have to work with people from other fields, and a common misperception amongst students is that ABA is the only field that has professional and ethical guidelines. All professionals that you would interact with have their own set of ethical guidelines, and it can really help the success of consultation if you become familiar with those guidelines. So for example, if you work a lot with speech therapists or occupational therapists, to be familiar with the guidelines for those fields. So informed consent can relate to research studies in which a participant would give their explicit permission. It can also be just in service treatment, but the participant gives their explicit permission before you do any assessments or treatment. And you can only seek to get this permission after you've given full disclosure and information to the participant about either the research study or the treatment plan. There is a test for informed consent. The person must have demonstrated capacity to decide. it must be voluntary, and they must have adequate knowledge of all aspects of the treatment. So you can't tell them only a little bit and not give them full details. You have to give all of the details about the treatment. In some discussions with students, I've also heard an argument that, well, if I tell them what I'm going to do, then is it going to be effective because they're already going to know what we're doing for treatment? So it may not be effective because they're going to know that I'm reinforcing their positive behavior in the grocery store, for example. But that's why we do informed consent. You want the person to be aware of what strategies you're using and to have given consent for them. So that is not an argument that you can use against giving a participant all the aspects of treatment. You're still mandated by our professional and ethical compliance codes to do that. So the person must have capacity to decide. They should be able to select and express their choices and engage in a rational process of decision making. You may have to be creative in order to give them the opportunity to make choices. For example, maybe doing a preference assessment, and there's many procedures for that, but sometimes those clients who could not express their needs and wants verbally, you could do with some nonverbal preference assessments. And you also need to recognize that clients may not understand all aspects of the treatment, so as it becomes more complicated, you may have to find different ways to communicate changes in the treatment plan. If an individual is not capable of consenting, and by this I mean a court has decided they need additional protections. So this is not as much an arbitrary decision, but it's looking at needing additional protections. You can obtain consent to a surrogate or guardian. So, in surrogacy is a legal process by which another individual is authorized to make a decision for the person deemed incompetent. With a guardian, this differs because they actually have legal custody of the individual. And making decisions about surrogacy and guardianship is especially important for transition-age youth. Now, what might an example of a surrogate be? When I was a teacher, I often had surrogates appointed for children by courts who were in state custody. And so they would come in and sign IEPs for the child for the next year and make decisions on what was in the best interest of that child. Now, a guardian, I also worked often with guardians, like maybe their aunt has custody of them and that's their guardian, or maybe parents of individuals older than 18 have guardianship of them because they've been deemed not able to make day-to-day decisions and be safe in those decisions. So surrogates have to consider when they make decisions for clients their current diagnosis and prognosis, their expressed preference regarding the treatment at issue. So if the individual always says, I hate when I have to go to the gym to exercise on the weight machine, then the surrogate may have to consider that maybe bowling would be a more appropriate leisure activity. You have to consider the person's relevant religious or personal beliefs, their behavior and attitude towards medical treatment, their attitude towards a similar treatment for another individual, and if they express concerns. And these could be expressed concerns verbally or non-verbally. So you might look at the expression on their face, whether they cry out during the treatment, whether they try to run away, because that's expressing a preference. You also have to consider the effect of the treatment on their physical, emotional, and mental functions. Again, physical pain, whether there could be humiliation or loss of dignity And these would be, again, kind of considerations in general. Would this be something that I would be comfortable with? So, for example, would I want somebody dressing me with the window open? That would be potential cause for humiliation or loss of dignity. And the effect that the treatment would have on the life expectancy of the person. So guardianship may be sought when treatment is deemed necessary. The greater the degree of guardianship, the less legal control a person has over his or her own life. So in surrogacy, it may be more like you're having a surrogate make decisions at maybe an annual meeting. But in guardianship, they're really making those day-to-day decisions about the client as well. And if your goal for an individual client is that they become more independent, or the idea is that they will eventually live and work independently, then seeking guardianship should only be done as a final option, just because of the limitations it invokes on future opportunities. And courts can decide on a whole continuum of guardianship alternatives. There could be full guardianship, in which basically someone is making every decision for the client. Limited or temporary guardianship, so maybe you only need guardianship for a few months while you're recovering, or an individual only has guardianship when it relates to financial decisions or medical decisions. You want to make sure that you stay connected with local, state, and federal regulations related to guardianship. Now back to consent. Consent is considered voluntary when it's given in the absence of coercion or undue influence, and when it's issued with the understanding that can be withdrawn at any time. So even if a client consents to a treatment plan, 2 weeks later they decide that the treatment is not improving their life, or they just don't like the treatment, then they have the right to withdraw their consent. You want to make sure when you're communicating with clients, and remember clients can mean the individual or their parents or second or third party clients, you want to present the treatment in clear, non-technical language and include all important aspects of the treatment plan, the potential risks and benefits, any potential alternative treatments, and the right to refuse continued treatment at any time. There are a few instances where you can treat without consent. That would be a life-threatening emergency, imminent risk of serious harm. You cannot do it when a patient or parent simply refuses. Instead, you have to work through the legal system in order to get consent for treatment. And as soon as possible, you should rectify treating without consent and get consent for treatment. Something that began to occur more and more in the 80s, which is why the Blue Ribbon Panel was commissioned, was third-party involvement in services. So you may get requests for services from schools, clinics, community agencies, and when you get that, you want to define your role, probable use of services provided or information obtained, and limits to confidentiality. And if there's a potential for a conflict of interest, you want to make sure that you disclose that and make a referral if you cannot treat the client based on that conflict of interest. Confidentiality is an important ethical consideration in daily practice. You should not disclose information about a client unless you have a signed consent. So if a school or a teacher comes up and asks you, you have to make sure that a consent is in place in order to disclose information. Some limits to confidentiality is in cases of abuse or impending harm to the individual or others is known. The rights and prerogatives of clients. You want to support individual rights under the law, provide accurate and current set of your credentials upon request. If you're going to audio or videotape, you have to have consent for this. Then if you're going to take these audio or video recordings and play them at a conference, for example, you would need an additional consent. You also need to inform clients of their rights to complain about your practice and give them information about that process of complaints. Clients have a right to an environment that's engaging, where reinforcement is readily available, problem behaviors are reduced, reinforcement contingencies are effective, and the environment is humane. The environment should also include functional skills instruction and maintenance supports, actual observations of treatment, not just basing it on records. The environment should be the least restrictive. I think this is often something we struggle with as behavior analysts, because we may see one environment as more effective, like they could learn more skills more rapidly, but we have to balance that with the need to include them in community settings or in inclusive environments. And this is especially important because we're always working towards life after high school. So a lot of times as behavior analysts, we work with preschoolers, and we have to realize that one day they're going to grow up. So providing the least restrictive alternative will better prepare them for the future. You also want the environment to be stable. So you don't want an environment where the staff is constantly changing, where they're with different peers each day, or the programs change based on what individual staff like. You also want the environment to be safe. This includes getting the necessary health and safety inspections and also peer review of treatment and also peer review of the environment. You want to make sure that you're maintaining confidentiality in your professional and scientific relations and within your organization. You want to be clear about what confidentiality means in your practice and how communication will be made. Some ways that you can protect confidentiality are lock cabinets, password protect things. If you get work email on your phone, that's often an area of lapse. People don't think to password protect that email. You also may want it to be password protected beyond just the initial code that you enter, because if you enter that code and other people get on your phone, then you want to make sure that they could not go into your email. You also want to confirm surrogate and guardian status before providing information. I had a colleague that ran into a situation with this because there was a custody situation in which the dad did not have right to medical and educational records. My colleague did not confirm that before they disclosed some very detailed treatment plans, and this actually got them in a lot of hot water. Thankfully, the situation worked out, but you really could face discipline procedures not only within your organization, but even within the field if you don't confirm surrogate and guardian status. As far as disclosure, you don't want to disclose confidential information unless it's for a valid purpose or you have appropriate consent forms. If you're not sure, don't disclose it till you are. Code 2.09 relates to treatment efficacy. You have a responsibility to recommend scientifically supported, most effective treatments. And you have the responsibility to review and assess the effects of all treatments, including those recommended by other professionals. When considering which treatments to implement, you want to consider, is it well tested? Has it been replicated across settings, populations, and skills? And is it published in peer-reviewed journals? Questions to consider when determining treatment: is the client willing to participate? Are the caregivers willing for the client to participate? Has it been successfully treated? in the behavior research literature? Is public support likely? Do you have the experience to deal with the problem behavior?